Jai Sri Radhe, Progressive Shorthand, March 2021, Exercise 25 Legal, Part 2, Dictation 80 words a minute, start. That the effective date has not been defined in the definitions, full stop. The words effective date mentioned in Article 24(3) have to necessarily be read with the earlier part of the same article, that is, first 5 years of the terms of contract. Hence, the effective date has to be read as the opening date, since the term starts only from the opening date. Otherwise, reading effective date in a manner urged by the respondent would render the first part of the clause, that is, first 5 years of the terms of contract, as notice redundant. Full stop. According to the learned counsel, even physical year is a defined term of Schedule First, Clause 8, and commences from the opening date. Also, the expression term is defined in Schedule First, Clause 17, as set out in Article 24. Full stop. It is settled law that the agreement has to be read harmoniously in keeping with the principles of business efficacy as applicable in commercial contexts, and while looking at other clauses in the agreement to give effect and meaning to the intent of the parties. Full stop. The learned counsel stated that reading of Article 9 first and second read with Article 12 makes it very clear that the management fee and the incentive fee is also payable from the opening date only. Full stop. Article 9 is absolutely clear and only covers certain pre-operational activities prior to the opening of the hotel by the operator, for which the respondent had to bear the said pre-operational expenses. Full stop. Para. Article 2nd, sub-clause 2, detailing the various activities to be done by the operator, that is, the petitioner herein relied upon by the respondent on a plain reading clearly shows that except for the pre-operating expenses, clause 2.1 referred above, all other duties and responsibilities relate only to the operation and maintenance of the hotel. Full stop. For the period May 15, 2015 till July 21, 2017, the hotel was under construction and non-operational, and hence the term commenced only from the opening date as defined under the agreement. Full stop. Thus, till July 2022, the agreement cannot be terminated for any reason whatsoever. Full stop. In support of his submission of interpretation of a contract, the learned counsel has relied upon the various judgments. Full stop. According to the learned counsel, as the respondent is disentitled from terminating the contract during the lock-in period under any circumstance, either with cause or without cause, full stop, the agreement is not hit by section 14 or 41 of the Specific Relief Act 1963, full stop. Rather, the mandatory lock-in period is an express negative covenant within the meaning, full stop.